Namaskar. Good morning to all of you. Today, the third day of our international webinar on the constitutional obligation, rights, value, duties, and the responsibilities of citizens. So, today we have with us Professor Tuhin Kanti Das, the first speaker of the day. Just going to lecture, I would like to introduce Professor Vikas Chandra Das. He is uh, graduated from uh, he is MA from uh, sorry sir. Now, sorry for interruption. Now I'm going to introduce Professor Tuhin Kanti Das. He completed his BA from uh, Vidyasagar University, Medinipur, MA and MPhil also from the Bardhaman University, and he also published many articles and also published many books on different topics and subjects, and he also uh, took many administrative responsibilities. So I would like to invite Professor Tuhin Kanti Das to deliver your lecture. Thank you, sir. Over to you.
Thanks, everybody. It's a great opportunity for me to be with you. And I am thankful to the authority of Ramnagar College, Honorable Principal Sir, and faculty members, uh, my younger brother Samuel. Actually, they have given me the opportunity to attend the program as a resource person. So I'm really grateful. All. And as per the topic, that is the theme, that is constitutional obligation, citizen rights. So I have deliberately chosen a topic that is the liberal democratic values and the Indian constitution and estimate. That is the title of the lecture that I am going to tell you. So liberal democratic values and the Indian constitution and estimate. At the outset, I would like to mention that is liberal democratic values. What do we understand by liberal democratic values? All of us, we know that liberal democratic values is derived from the political philosophy, that is liberalism. So what do we understand by liberalism? That is, liberalism is a new political philosophy of the new social class emerged in Europe in very beginning of 17th century. And in this regard, political activist and the noted Marxist political thinker as well as activist, Lenin very categorically mentioned that liberalism is the philosophy of the rising bourgeoisie. Bourgeoisie is a new social class which was emerged in Europe, especially reference to England, France, and other countries. Very beginning of 17th century. So it was a philosophy of the new social class that is bourgeoisie, and to protect the material interest of the bourgeoisie of a new political philosophy that emerged in Europe. So liberalism is also a way of life. At the same time, liberalism is a way of life. Liberalism is a philosophy. Liberalism is a way of life. So of that very political philosophy which was emerged in Europe in 17th century, of it propagated some values as a, if you consider some political and economic events as a whole. In 1688, that is Glorious Revolution. 1789, French Revolution. 1776, American War of Independence. This is a political event. And 1750, that is Industrial Revolution, that is also an economic event. If we take into account these, the full political message of these first three political events, then we will see the political message that is, say for instance, Glorious Revolution in 1688 in England it occurred, and John Locke, the famous theorist, founder of liberal political theory, liberalism, liberal political ideas and values, he mentioned there is three important natural rights: right to life, liberty, and property. So, according to his view, these are the natural rights, and that should be protected. It is the obligation of the government to protect the life, that is liberty of the individual, and the property of the asset. 1789, that is French Revolution. French Revolution, the political message was very loud and clear. In French Revolution, that is a liberty, equality, and fraternity. Liberty means the liberty of the individual, individual liberty. Equality amongst the members of the society. And fraternity, that is a feeling of brotherhood as well. And the American War of Independence, the message was very loud and clear that I have told you earlier. That is American War of Independence. There is the one important slogan: no taxation without representation. Mind it. No taxation without representation. In the declaration of, they very categorically mention that by birth we have acquired something. Something means that is the right to life, liberty, and what he has got, and it should be protected at any cost. And in future, when the government will form, obviously that government, it is the moral duty of the government as a whole to protect it. So all these things, if you consider the political significance of these three events, that is Glorious Revolution, French Revolution, and American War of Independence, we could easily follow the very of the spirit of these three political events as a whole. That is, individual is the center, was in center, and the life of the individual, the personal liberty of the individual, and the property to be protected. So what I have told you earlier, the liberalism is nothing but a way of life. Liberalism is the philosophy of the rising new social class, that is the bourgeoisie. So that should be considered very seriously. The liberalism is connected with the bourgeoisie as a whole. Bourgeoisie is the new social class. And now if you connect the impact of industrial revolution in society, then you will see industrial revolution actually two major social classes. One is the bourgeoisie, one is the capitalist class, and other is the working class. So these four events as a whole, first three, that is the political events, and the last, that is 17th, that is an economic one, propagated some ideas and values, and liberal values is derived from the show I have already mentioned earlier. That is, when we are going to discuss the liberal democratic values, we should keep it in mind. That is the liberal philosophy, liberal democracy, liberalism as a whole. And there is a classical liberalism, mind it. That is a classical liberalism. It emerged in Europe, with special reference to England and France. Later is we acquainted with this in latter phase. So anyway, so this event, the political significance of these four events, as for what I have told you earlier, was very important in our discussion. In this regard, I can give you another example. Say, for instance, before French Revolution, the attitude and outlook of the Bourbon rulers. There are two important things that I would like to mention. One, 14th Louis or 16th Louis, they very categorically mentions, I am the state, and what I desire is law. So mind it, I am the state and what I desire is law. That was the situation. That was the condition of the France during 16th century or 17th century. That was the situation. And the French society, that was a highly stratified society. First estate, second estate, and third estate. So after the downfall of the Bastille Fort, that is the downfall of the Bourbon dynasty. They propagated, the French common people propagated of the idea of equality, liberty, and fraternity. Actually, in medieval Europe, that was dominated, medieval Europe, dominated by the Christianity. Christianity is a organized religion, and the role of the individual in a society was not so important. That is a marginal role. Everything, the life, every aspect of the life, that was dominated by the Catholic values and ideas as a whole. So life was dominated by Christianity. Christianity is an organized religion. With the advent of European Renaissance, when the critical rationality emerged, came into critical rationality, the way of looking from a different perspective, that is a scientific temperament, reason, logic, everything. In this regard, that a medieval Europe, medieval period, as Optaker mentioned, that is the age of faith. On the other hand, the modern, that is the age of reason. So reason, logic, scientific temperament, which is actually the European Renaissance, that was the very important ingredients of European Renaissance, that is to develop scientific temperament, to establish a causal relationship, to judge everything from a critical standpoint. So, with the European Renaissance, one thing, and that is sea trade, commerce. These are the played an important role, and the concept of new man, that emerged out of the socio-cultural movement in Europe. So the new man, having some qualities as a whole, that is property, that is sacred for me, individual liberty, it should be protected at any cost. So freedom of thought and expression as a whole. And at the economic front, what we have seen, say for instance, the concept of laissez-faire, what Adam Smith has mentioned in his writing. So all these things shaped the uh, all set the cultural ambience as you cultural ambience and individual their interest, it should be protected at any cost. That was the basic. If you consider John Stuart Mill, John Stuart Mill is popularly known as a theorist of that is when we are going to talk about liberty, we have to mention John Stuart Mill. And another, the book that is on liberty and the representative government, published in 1861. So, and what Mill mentions has famous argument over body and mind, man is sovereign. Mind. John Stuart Mill very categorically mentions that is over body and mind, man is sovereign. So religion is not in a position to control him. Other social institutions that is not in a position to impose any kind of control on him. So he very categorically mentioned that over body and mind, man is sovereign. The concept of laissez-faire, free trade, the concept of utilitarianism, which was propagated by Jeremy Bentham. So all these things, it created a new cultural ambience in Europe. And liberalism, as well, that was the foundation. That was the foundation. It created the platform. Now, on who is the idea of liberalism came into. And with these things, that is the concept of representative democracy, representative government, idea of republicanism, concept of citizenship. These are the basic attributes of political. These are the basic attributes of liberal political philosophy. And when we are going to talk about a liberal democratic political system, then you will see that is the concept of representative democracy, representative government, the republicanism, all these things. So it should be of concept. And now, liberal democratic political system, that is the based on the philosophy, that is the political philosophy of that is liberalism. What we have seen in a liberal democratic setup, in a liberal democratic political system, that is the concept, that is a power is limited. Limited in what sense? The ruler, they are selected by the rule. They are elected by the ruled, and the ruler is using political power for a definite period of time. It may be 4 years, may be 5 years, or 6 years, whatever it may be. Ruler is using the political power, that is the state power, for a definite period of time. Power is limited. The power is diffused. Political power is diffused, is limited. And on the other important thing is that that is the citizens of the members of the political system, they are enjoying certain rights in order to protect their interests, in order to control, in order to impose a considerable amount of control on the ruler. So these are the important aspects of a liberal democratic political setup. Long back, when of American or I am sorry, that English writer, modern politics and government, that is Alan R. Ball. He made an attempt that to classify the modern political system as a whole into three. One is liberal democratic political system, another is the totalitarian, and third is the authoritarian. And according to his perception, later the other political scientists of United States of America, they mentioned that liberal democratic political system is an ideal political system. And in future, that very political system, the values of that very political system, that is liberal democratic political system, will be followed. It has an ideal system and it will be followed. In this regard, I would like to mention here that is of Francis Fukuyama in his famous, that is a book, End of History and the Last Man. So, the liberal democratic political system, that is ideal. It is a valid political system. The ruler is enjoying power, that is right, but selected by the ruled people. Their power is limited, in a sense, limited by the constitution, limited by the other institutions also. The political power is really a pluralist in nature. Power is not unlimited like the authoritarian or totalitarian system. So in future, that very political system will survive, and that very political system will be considered as an ideal political system, and that will be followed by the other. Even Huntington in 1968, the famous book Political Order in Changing Societies, and in
Sorry, sir has removed. হ্যাঁ স্যার আপনি please wait for a minute. Sir is joining.
Am I
Yes,
audible,
sir.
Samal?
Yes,
Okay.
yes.
Okay.
Continue, please.
Okay. So, what I have mentioned earlier, that is political order in changing societies. And what Fukuyama, that is end of history and the last man. So they think that liberal democratic political system, according to their perception, is an ideal political system. And in future, the future world, they all the countries follow that the basic spirit of liberal democratic politics. Now, what I would like to mention here, I have already told you the basic aspects of liberal democratic political system, the values, what they are cherished. So in 1950, when the Indian Constitution that was enacted, the constitutional makers of our country, they were heavily influenced by the liberal democratic values. That was my first statement. 1950, the new constitution came into being, that was enforced. And the constitutional makers, Jawaharlal Nehru, Sardar Vallabhbhai Patel, Maulana Azad, and the other members of the Constituent Assembly. Most of the members, they were highly educated, influenced. Even Dr. Ambedkar, the chairman of the drafting commission. they were heavily influenced by the European tradition, by the liberal democratic tradition, and they incorporated so many things of Indian constitution as a whole. And in this regard, I would like to request all of you to consider the three important aspects of the Indian constitution. One is the preamble, and second, that is the chapter that is the fundamental rights, and third, that is the role of the judiciary, with special reference to High Court and Supreme Court. And in preamble, if you go through the text, perhaps all of that we know, if you go through the text, first, we the people of India. What American president mentioned earlier in 19th century, so of the people, by the people, and for the people. So we the people of India, then that is the first issue that is mentioned, that is the issue of justice. Perhaps you know, the British political thinker, that is Ernest Barker. He was an idealist political thinker. In 1950 onwards, perhaps 51, he wrote an important book, that is Principles of Social and Political Theory. And in the introduction of that very book, he categorically mentioned, actually he was heavily influenced by the Indian Constitution as the concept of justice was incorporated in it. Justice stands for social, economic, and political. And mind it, this concept of justice is basically a distributive in character. Now today we are talking about distributive justice, procedural justice, and other things. In 1950, when the Indian Constitution was enacted, thanks to the constitutional makers, they very mentioned the concept of justice and to uphold the idea of justice. Now we are talking about a concept of that is talking about the distributive justice. At that time, they mentioned the justice that should be ensured. Another, that is the liberty of thought, expression, belief, faith, and worship. Mind it, all these things that is basically followed by the liberal spirit. What Mill mentioned, what long ago John Locke mentioned, even the concept of popular democracy that is propagated by Rousseau. What John Mill mentioned, and influenced by the entire European tradition, the tradition, obviously, the tradition of liberalism as a whole. Actually, perhaps you know, that is communism, that is a political ideology that also emerged in Europe. The concept of fascism, that was also emerged in Europe, that we all of us that we know. But basically, the Indian freedom fighters, the Indian political leaders, they basically influenced by the European tradition, liberal European tradition, and wanted to introduce the same thing into Indian context. So the concept of justice. And what I have told you earlier, in that very book, Principles of Social and Political Theory, Ernest Barker very categorically mentioned that credit goes to the the constitutional makers. They give due importance to the issue of justice. And second, that is the concept of liberty, thought, expression, belief, faith, and worship. Even the concept of equality. Perhaps you know that it was the political message of the French Revolution, that is, all men are created equal. This is the first time that was the political message of the French Revolution. They propagated the idea that is, all men are created equal. And the American constitutional makers participated their war of independence. They also believe that is, all men are created equal. So equality, at least political equality, that should be established. And perhaps you know, at the time of independence in 1950 onwards, when the constitution was enforced, we got the that is right to vote. And I think it is the very essence of post-colonial democracy as a whole, what India has India practiced last 75 years, which is popularly known as the post-colonial democracy. So mainly that is the concept that is universal adult franchise. Perhaps you know in Europe that the particularly the female, they got the right to vote in either 1930 or 1948, even in other countries in 1930. But in India, that is the policy, that universal adult franchise, that was got the right to vote at the same time. So they tried their level best to establish the concept of it. And another thing that is uh, during election, what we have seen, the one person, the policy is one person, one ballot, one vote, and one value. Mind it. In spite of that, Indian society is basically divided into caste, creed, and religion. Hierarchy is there, that we know. But in order to establish the political equality, so the concept, that is the one person, one ballot, one vote, and one value, that was also introduced by the constitutional makers. So credit goes to the constitutional makers. They tried their level best to introduce some values, some basic values of the European liberalism, the basic political values of liberalism. They introduced it. Even that is the concept of the fraternity. Here I would like to mention fraternity, that is a brotherhood. That is fraternity, means that is it stands for the concept of brotherhood. So in preamble, very categorically, they mentioned these four political values: justice, liberty, equality, and fraternity. And I have already told you, they influenced by the European tradition, particularly the liberal tradition as a whole. They incorporated these values in Indian constitution. This is the first thing. Another important issue, that is the third chapter of the Indian constitution, which I think that is the soul of the Indian constitution. Soul means in Bengali, that is Atma, soul of the Indian constitution. And in third chapter of the Indian constitution, there are so many rights in order to protect individual liberty. From Article 14 to the concept of equality, then right to liberty. And right to liberty, Article 19. Now, I request you to remember Locke and Mill. It is fact that we were basically influenced by the American, actually in American constitution, in constitution of the US, citizens' right, that is very categorically mentioned, heavily influenced by it. But at the same time, the liberal values, the liberal tradition that was mentioned by Locke or even John Stuart Mill, and Article 19 is very important, and Article 21 also. In latter phase, what we have seen, they expanded the concept of right to life. By the end, credit goes to the Indian judiciary, particularly the Supreme Court. And perhaps you know, Justice P.M. Bhagavati, public interest litigation, expanded the concept of right to life. Even one thing, that is right to privacy. Mind it, in 2017, Honorable Supreme Court has issued a verdict that privacy is your fundamental right. Mind it, what Mill mentioned, that is over body and mind, man is sovereign. I think the justice, honorable justice of the Supreme Court, they afford the IT. That is, being a individual, it is his, it is the fundamental right of that very person to maintain the privacy. So, the honorable judiciary, Indian judiciary, have played an important role of to protect and promote the rights of the individual. Now, that is Article 32, which is popularly known as the right of the rights. Actually, Constitution has given us so many rights, but a mechanism should be there through which the rights of the individual can be enforced. So, Article 32 is popularly known as the right of the rights. And if you go through the text, habeas corpus, mandamus, all these things, these are the basically Roman influenced by the so habeas corpus, mandamus, all these things heavily influenced by such ideas and values incorporated in the Indian Constitution. And Article 32, very important aspect of the Indian Constitution. If your right is violated, the right of the individuals is violated, then that very person can go to the court of law to get justice. But there should be an instrument without which you cannot lodge a complaint. You cannot go to the court to get justice. So Article 32 has given us ample scope and opportunity as a whole to go to the court, either 226 in case of High Court and Article 32 in case of Supreme Court. So our constitution at the same time, that is the main pillar of our political system, that is the judiciary, playing an important role to protect and promote the rights of the individuals. So I think, so this in first I have mentioned, that is the preamble. Second, I have mentioned the Article 3rd chapter of the Indian Constitution. And third, that is the role of the judiciary. If you consider all these things, you will see the constitutional makers has given something mentioned in the Constitution, influenced by the European, influenced by the liberal values. But the judiciary, last 75, if you consider the activities of the judiciary as a whole, which is popularly known as the judicial activism, what I mentioned, from early 50 to late 70, judiciary was proactive, but in defense of that very activism, considered as a act to defend the status quo, to maintain the status quo. But in early 80s, what we have seen from early 80s, the same judiciary played an progressive, played a dynamic role to protect the rights of the individual, the community as a whole. And so these three aspects what I have mentioned earlier. And in this regarding the discussion, I just mentioned the writings of an American constitutional expert, that is Grenville Austin. Perhaps you know, he wrote two important books on Indian Constitution, Working of a Democratic Constitution, as a very important book, Indian Constitution, Cornerstone of a Nation. In these two books, particularly the Cornerstone of a Nation, the Indian Constitution, Cornerstone of a Nation, he very categorically mentions the Indian Constitution that is a success. What he mentioned, if you allow me to quote him. Just a minute. What the Indian Constitution cornerstone of a nation in 1972. I quote, the Constitution has so far been a success because both the ends it has proclaimed and the means it has laid down for achieving them have been popularly accepted and have already worked beneficial change in Indian society. Mind, in 1972, the American scholar, that is Grenville Austin, several times he visited India. In latter phase, he wrote an important book, that is Working of a Democratic Constitution, Working a Democratic Constitution. So in 72, he mentioned what the ends it has proclaimed and the means it has laid down. So then you may raise the question, what is the means? The liberal democratic tradition tells us that a consensus mode, change is required, change is inevitable, but it should be on a consensus, the model of consensus. And Grenville Austin, in his book, he mentioned that the model of consensus is followed, and consensus is a liberal democratic value. Consensus is a liberal democratic value cherished by the liberal democratic scholars, the thinkers. And in India, that is the negotiation. In India, that to follow the model of consensus, and as we are heavily influenced by the European tradition, with special reference to liberal tradition, that is the consensus model is followed to address the problems, to address the issues of the Indian society, Indian polity as a whole. So, according to Austin, that is the model that is followed, which I have told you, that is a consensus model. So, from that point of view, I can say that the Indian Constitution, the constitutional makers, they propagated the liberal values, they cherished it, they practiced it, and they very categorically and elaborately discussed and mentioned in Indian Constitution. From that point of view, we can say that it is a success story for us. We are going to celebrate 75 years of India's independence. And if you consider the issue of political stability as a whole, what Huntington has mentioned very long back in 1968 in Political Order in Changing Society. The order, stability, these are the issues. And Indian credit goes to the Indian constitutional makers, credit goes to the policy makers, credit goes to the policy implementers as a whole, those who are going to implement the policies as a whole. So political stability is maintained, and political stability, that is also what one thing, another issue I have forgotten to mention. In India, what we have seen, that is your military is controlled by the civilian government. It is basically a liberal tradition. American scholars, particularly Huntington and others, they time and again pointed out that is a military under the supervision of they should act under the supervision of the Constitution, under the supervision of the civilian rulers. So in India, in case of Pakistan, make a comparative study with other countries, you will see Bangladesh, Pakistan and other countries, what has happened. Even in 1950, so many new states emerged. But sorry to say, what we have seen, in most of the third world countries, power was captured by the military junta. But in case of India, what has happened? Still now, the military is under the supervision and under the control of the civilian government. That is a liberal value. That is a liberal value. And still now we are following, we are guided by that very liberal tradition. Anyway, time is over. Last but not the least, I just mentioned one important issue and I shall finish my lecture here. We are talking about so many things, but one thing that is in the Indian Constitution, what the constitutional experts have mentioned, that is a centralizing tendency that they have mentioned, that is with a strong centralizing tendency, and the powers with special reference to the emergency provisions of the Indian Constitution 352, 356 and 360. And in 1975, internal emergency was imposed, perhaps you know, the then Prime Minister of India imposed internal emergency. So through the imposition of such type of powers, the rights of the citizens that was curbed, the democratic institution that was bulldozed, detention, individual rights were curbed, censorship was also imposed. And in 75 June, in the month of June 1975, near about 45 years ago, that was imposed. Democratic rights of the citizens suspended, censorship was imposed, even detention of the individual, that we have seen. So, it is right. It upholds our constitution, the democratic spirit, the liberal values as a whole. But there are certain provisions. There are so many certain provisions are there. So Indian state, what we have seen in 75, through the proclamation of emergency, the democratic rights, values that was suspended. So this is the only one instance. Taking clue from the constitution, what I have mentioned, 352, internal emergency was imposed. At that time, externally emergency was there due to Bangladesh war in 1971. But internal emergency was imposed by the then Prime Minister of India in 1975. So, democratic rights of the citizens that was suspended, censorship on media that was imposed. So, when we are going to talk about the democratic spirit, liberal democratic values and the Indian Constitution, we should keep in mind these political event as a whole. With these few words, I would like to conclude my lecture here. I am thankful to everybody, particularly special reference to Ramnagar College. They have given me the opportunity to be with you and the audience, the other resource person. I have tried my level best to say few words in this regard. With these things, I would conclude my lecture here. Thank you all. Thank you.
Thank you, sir. Thank you for valuable lecture. Now, I would like to invite Professor Vikas Chandra Das for the next lecture. Now, I am going to give a brief introduction. Sir, Associate Professor of Assam University. Sir has done his MA from Utkal University, MPhil from Dr. Babasaheb Ambedkar National Institute, Indore, PhD from Institute for Social and Economic Change, and Sir has 15 years teaching experience and 9 PhD scholars awarded under his supervision, and 4 scholars is running under his supervision, and 8 MPhil scholars also awarded under his supervision. And he also attended and 17 national and 6 international seminars Many book chapters and books were published by him, and he also uh, took many administrative responsibilities and awarded from different institutes. Sir, now I would like to invite you to deliver your lecture. Sir, over to you.
Thank you, Chairman. Good morning to all. Respected Chairperson, Sri Suprakash Giri, Patron and President of Ramnagar College, West Bengal. Dr. Ananta Mohan Mishra, Principal, Ramnagar College. Professor Samuel Paul, Secretary, Convener and Head of the Department, Ramnagar College, West Bengal. Professor Rajesh Patro, Joint Convener of this international webinar, and respected members of this webinar organizing committee Professor Prashant Kumar Pradhan and Professor Ranjit Kumar Mandal of Ramnagar College, West Bengal. Distinguished participants and paper presenters and students who are present here. At the very outset, I would like to express my happiness and feelings of happiness for having been invited and in this international webinar as a resource person, and I feel honored. And I this particular international webinar titled "Constitutional Obligations, Values, Rights, Duties, and Responsibilities of Citizens." I thank the organizing committee, members and conveners of this webinar for inviting me, and I would like to, before I start the lecture on this topic, I would like to speak one thing on so far as the citizen charter is concerned. Out of whatever has been told, has been written on citizen charter, one common thing that is there. So, with regard to citizen charter, is that the many CSOs, educational institutions, government organizations are advised to take consistent efforts to educate people on citizen charter. As Ramnagar College has taken initiative to organize this international webinar on constitutional obligations, values, rights, duties, and responsibilities of citizens, and has dedicated a technical session on citizen charter, I especially thank for this to the Ramnagar College, and I hope this webinar and my discussion on the topic citizen charter will definitely help the participants, students to understand the concept of citizen charter and realize the need and importance of this topic for performing the role in a democratic country like India. In a democratic country, citizens are considered to be the masters of the people, masters, and the service providers as the servants. Therefore, democracy requires citizen engagement. That means people's participation is the mantra for the success of a democracy. If we look at the theories of democracy, now we find that the democratic theories are evolving. Earlier, we are talking about the representative theory of democracy. And today, we are talking about the participatory or deliberative theory of democracy. In the traditional representative theory of democracy, the role for a citizen was just a voter to elect the representatives, and they would be making the law for the people in the parliament or legislative assembly. However, this concept of a or theory of representative democracy has been criticized for giving a very minimum role to the voters, and therefore a renewed version of a democratic theory that has been appeared in the form of a deliberative democracy, which is a form of a democracy in which deliberations in the form of a discussion, constructive criticisms, opinions, views, and suggestions lead to the policy making. So far as the deliberative democracy is concerned, in other words, the decision making by the government must be followed by the deliberation. And how the deliberation has to be taken place? The deliberation in the form of a discussion, constructive criticisms, opinions, viewpoints, suggestions. These are the processes through which the deliberation has to take place. So far as the deliberative democracy is concerned, Jürgen Habermas, David Held, Joshua Cohen, John Rawls, and Amy Gutmann, including these thinkers, there are so many thinkers, those who have contributed for the deliberative democracy. And this deliberative democracy is based on the people's participation, and before participation, the knowledge, information of the voters or the citizens is the crucial need, and that is why for the success of a deliberative democracy, we need to have a citizenry who are empowered with the information, knowledge, and the transparency. So, in recent times, we are all talking about good governance and smart governance. So, good governance is a process in which different stakeholders are supposed to be partners of decision making. Earlier, we are talking about the decisions to be made by the government, but in recent parlance of a good governance, we are talking about the stakeholders which has been revised to include civil society organizations and the business organizations. We are talking about government, civil society, and citizens or business organization, market, civil society, and CSOs. Market, government, and civil society organizations. And smart governance has been conceived to address this question of good governance. What is that smart governance? Smart, S-M-A-R-T, A stands for simple, moral, aim for moral, A for accountable, R for responsive, and transparent, T for transparency. So these are the actually principles of good governance and smart governance. And in this connection, the role of citizen charter or the information of the citizens also plays quite crucial role. And with regard to the discussions in the current literature, so far as the exit and so far as service delivery is concerned, two important concepts are discussed. These are exit and voice. Exit is a concept which refers to the ability of the service recipients or ability of the service recipient to exit or to have a leave from the service providers, from the service provision. That means the right or the opportunity that is enjoyed by a customer or a consumer or a citizen to exit or to take leave from a particular service. That is called exit. And another concept that is understood or that is always discussed with regard to service delivery, that is the concept of a voice. Voice means it is a space for the public to raise their concern, their opinions, criticisms, oppositions against the exploitative and the corrupt services, unsatisfactory services. That means the capacity of the citizens to raise their voice or to oppose or to criticize against the poor quality of services. That is called the voice. The question is, there are certain services from which the citizens do not enjoy the exit option. For example, electricity service. Electricity service is such a service where multiplicity of a service provision is costly. That is why it is the infrastructure that is in place that cannot be replicated, that cannot be multiplied. Therefore, one service provider has to be chosen, and in this connection, the citizens do not enjoy the exit option. They cannot exit because there is no alternative service providers. And in this connection, the role of a voice is quite important. In other words, the customers or the consumers or citizen as a whole, if they do not enjoy the option of exit, they must resort to the option of voice. And for that voice, the empowerment of citizens with regard to their information and the details of the quality and the standards of service that is existing or that is being given to them must be available to them. And this is how the concept of a citizen charter takes a prominent role. As we receive numerous services on day-to-day basis from various government departments, starting from the Gram Panchayat to the district level, to the taluk level, to the state and central government level, we must have detailed information in order to enjoy that service, the services that are being provided to us as a citizen. The citizen charter is conceived on the idea that the power of people is stronger than the people in power. So as a citizen, we require so many services, starting from, for example, caste certificate, driving license, vehicle registration, and sometimes those who are belonging to different caste groups, so OBC, creamy layer certificates, caste certificates, and birth certificate, death certificates, legal air certificates, water supply, electricity, all these services and health, road, whatnot. There are so many services, and we require these services as a citizen in our day-to-day life. And in order to effectively avail these services, we must know what is the standards. Where are those services available? What is the fee structure? What is the user fee cost? What is the time to be required by the service providers to supply us the service? And if the service providers fail to address our issues of service delivery, what are the forums or what are the who are the officers whom we can make a complaint, and if the complaints are made, on what time bound basis, on what time duration the complaint has to be resolved, and solutions has to be given. All these questions needs to be addressed, and citizen charter fulfills this desire or requirements of a service delivery. And if we are aware of the these issues in advance, it gives us a systematic guidance to take steps one after another to pursue our service. And if there is any delay, what step has to be taken, we are clear, and then we can take up this issue in a very systematic and logical way. And in this connection, the citizen charter is considered to be an instrument of information which is helpful for the people or the citizens who are seeking information and service delivery from different departments of the government. So citizen charter, then the question is, what is the citizen charter? How to define citizen charter? So there are various documents which exist in the government websites and citizen charter, especially on citizen charter, there are many literature exist. Most of the literature define citizen charter as a document of commitments made by the government organizations to the citizens, client groups in respect of the services schemes being provided to them or to be provided to them. So citizen charter is therefore a document which represents a systematic effort to focus on the commitment of the organizations towards the citizens in the respect of a standard of services, information, choice, consultation, non-discrimination and accessibility, grievance redressal mechanisms, and value for money. So these includes the expectations also of the organizations and the citizens, what they can expect from a particular service providers and what they can do if the particular services provided are considered to be poor or of the having no standard. And citizen charter is one of the documents that is available suo motu. That means the citizens don't have to apply for getting information, because citizen charters have been designed in such a way that it is readily available in different government websites and in the different government departments physically in the form of like a document which has to be displayed in various departments. If when the citizens enter the premises of the departments, they can see in that these documents has to be displayed in such a place so that they can easily readily get access to these documents, so that they can get enough information, required information, before availing a particular service. So citizen charter therefore it is a crucial document so far as the information and knowledge of the citizens is concerned. So far as the Indian Constitution is concerned, we have fundamental rights, and also there are there is a chapter, chapter 4 or part 4, that is the that has provided for the DPSP, Directive Principles for State Policy. So if we look at the preamble of the Indian Constitution, we'll find that India has been declared as a sovereign, socialist, secular, democratic republic, and it is committed to secure social, economic, and political justice, the liberty of thought expression, belief, faith, and worship, and to promote fraternity, assuring the dignity of the individuals and unity and integrity of the nation. The fundamental rights and direct principles of state policy, enshrined in part 3 and part 4 respectively, reinforce this faith of the constitution makers, pledging the nation to remove social imbalances by harmonizing the rival claims or the interests of the different groups in the social structure, and to build a democratic welfare state. These commitments require for their realization an administration which is effective, which is efficient, and sustainable. These demands of the Constitution requires an accessible, responsive, and participatory framework of administration that can deliver outcomes in line with the concerns of the citizens of India and offers them a sense of ownership. In this connection, the citizen charter plays a role to fulfill these demands of the Indian Constitution and expectations of the citizens of the country. So with this, I would like to, in my presentation today, I will already have discussed some conceptual part of the citizen charter. I will be discussing in my future part, my next part of the presentation with regard to what are the elements of a citizen charter, how the a very ideal citizen charter can be developed, what are the parameters, what is the history, or from where the citizen charter has come from, and what are the limitations that has been understood so far as the citizen charter and its working is concerned, and what are different examples, or what are the how the citizen charter is working in different states, so far as the existing available literature. That part will be discussed in the next course of my presentation. So far as the citizen charter is concerned, the need of a citizen charter is felt because of a dissatisfaction of citizens with the available services. People want good governance, but few are willing to give. That is why citizen charter is understood as a trust between the citizen and the government. Public servants are funded by citizens and they deserve services. So whatever public servants who are working, their salaries have been funded from the taxes of the citizens, and it is therefore the moral duty of the citizens to provide required services, quality services to the citizens. And citizen charter is quite effective for service delivery, and it heralds an era of citizen-centric administration. Citizen charter is the expression of an understanding between citizens and service providers with regard to the quality and quantity of services the citizens receive in exchange of their taxes. Citizen charter is an effective tool for right to information of citizens. It is a tool to facilitate the service with specified standards, quality, and time frame. So then what is the basic objective of citizen charter? Is to empower the citizens in relation to public service delivery. Citizen charter ensures that the power of the people remains stronger than the people in power. It makes a public institution transparent and accountable. It enhances the participation in governance process and the credibility of the government. The very existence of the citizen charter acts as a deterrent to the acts of the maladministration. It makes government more responsive and acts as an effective tool to engage the civil society and the citizens as a whole to curb corruption. The involvement of the consumer organizations, citizen groups, and the stakeholders in the formulation of the citizens' charters is therefore important so far as the development of citizen charter is concerned in order to enhance the standards of service delivery. Citizen charter helps in revamping the people's faith in confidence in the administration and the political executives by providing effective channels of redressal of citizens' grievances. So far as the citizen charter is concerned, some of the principles have been discussed, how these principles can make citizen charter more effective. And so far as the citizen charter's principles are concerned, the first principle that comes in mind is the quality. So the improving the citizen charter, the aims at improving the quality of services. Secondly, choice. So what is the choice? Means what the consumers need, what the people need, what is their options, what are the options available for them. That is the choice, wherever possible. And standards, specifying what to expect and how to act if standards are not met. So standards means what are the quality of the service that is available has to be specified. That is that relates to the standard. Value, for the taxpayers' money, the people are paying taxes and they in return require the services, and that is the value for money. Accountability, the individual officials or the staff, that are those who are in charge of or in the duty of providing services, they must be accountable, or they must be answerable for whatever their omissions and commissions, and that can enhance the citizens' strength to so far as the service delivery is concerned. And then finally, the one of the important principles of our citizen charter is the transparency. Transparency means it must be available to people without any without any effort. That means it must be readily available. That is called transparency. See, there is the service standards, service pay, whatever quality, whatever fees and all that is involved with regard to service delivery or a particular service. This must be readily available, and all information should be given to the citizens in advance, and there is nothing to hide. That is transparency. So in order to have a good citizen charter, these principles are always discussed. And the concept was actually, when we are talking about the citizen charter in India, first of all, we have to understand where from this concept has come from. The first thing that we talk about to citizen charter's origin is that the concept was first articulated and implemented in the United Kingdom by the Conservative government of John Major in 1991. And after the initiation of this citizen charter concept in the UK, in order to streamline the administration and make administration more people centric, the other countries started to follow this initiative so far as the citizen charter is concerned. The French government, in France, it is known as service charter, which was adopted in 1992. In Malaysia, it is known as client charter, which was adopted in 1993. In Canada, it is known as Service Standard Initiative, which was adopted in 1995. Australia also, it is available, and the service, it is known as Service Charter, which was adopted in 1997. So the question of this citizen charter, so far as India is concerned, it dates back to the year 1997. When there was a chief minister's conference, which was presided by the prime minister of that time, and how the different governments, state governments, and the different departments will develop a citizen charter in order to facilitate good governance, and how to bring citizens into the center of the service delivery process, how to promote information to all the citizens without any hassle, without any difficulty. That was the topic of discussion, and in that discussion, it was understood that the efforts should be taken by the different governments, different state governments, to be coordinated by the central government to develop a citizen charter. And with this in this context, the role of the various government departments to develop this was quite important, and therefore a roadmap was developed by the central government for the formation of citizen charters, and a task force was constituted with the objective of identification of all stakeholders and major services that are being provided by different departments. And the consultation was held with the clients and stakeholders and staffs of different departments. And preparation of a draft charter was made, and that was circulated among different stakeholders. And there was a consideration for the chapter by core group. And after the requisite modifications, the citizen charters were adopted by different departments. And now we can see in every department, every government website, every website of different departments, we find that there is a citizen charter. And not only that, when we visit any government department, we find one display board where we find the citizen charters of particular services that are being provided by the concerned department. So, so far as the Indian citizen charter is concerned, we find that the design that it has a cover page. It is based on a vision. It is based on a particular mission, and it mentions the service standards, and there is a mechanism for the redressal of the grievances of consumers, and the responsibility centers which section and what officers has to bear what kind of a responsibility with regard to service delivery. It is also mentioned. So, and it also discusses who are the clients, stakeholders for a particular service provision is concerned. And this Chief Minister Conference also developed certain principles with regard to citizen charter, and so far as the citizen charters model guidelines are concerned, it is understood that the citizen charter should to be useful, the charter must be very simple. So the discussions which took place by the different levels of officers and the ministers, it was discussed that the citizen charter must be quite simple. The first principle of the citizen charter that it must be simple. It must be written in simple language to be displayed at different departments so that people can understand. The charter must be framed not only by senior experts but by the interaction with the stakeholders, including the citizens. And that is why when a particular department seeks to develop a citizen charter, they have to give a wider advertisement of the process of a citizen charter preparation, and people will be invited to give their views and comments so far as because the user feedback is quite crucial so far as the development of citizen charter is concerned. And with some other procedures to be followed is that it must be very, very clear, it must be legible, it must be readable, it must be written in the local languages, so that the people who belong to different language and those who do not have the knowledge on English language should be able to read and understand what they can expect from a particular service. And so far as the development of citizen charter in India is concerned, there are many discussions on this, and to what extent the citizen charter has been fruitful to address the issues of the consumers, that has been widely debated, and many studies have found some lackings of the citizen charters. Therefore, they have tried to develop the guidelines for different departments to revise and to update the citizen charters. And sometimes they have given some guidelines what to do, what not to do. So they say that if a particular department is trying to develop a citizen charter, they must list areas of interface. Means what are the important areas of a particular service, this must be written, and phase out areas of for introduction of small steps. So what are the different steps to be taken must be clearly mentioned. Involve customers and staff in formulation and implementation of the citizen charter. Prepare a master plan for information and in implementation over 5 years or so that a budgetary allocation also can be made by the department to implement the plan, and try to win the customer confidence with certain visible measures, and inform the customers of the proposed commitments, use simple language and train the staff to make the citizens to make the citizens understand the if any difficulties are understood or if some difficulties are found. So there is also a list of do nots, like don't merely make haste, don't be unrealistic, don't take more than what you can commit, don't involve only senior officers so far as the formulation of the citizen charter is concerned. Don't rush into an overall package for the whole ministry or department or organization. Don't promise more than what you can deliver. Don't promise more than what is possible. So these are some of the don'ts which have been given as guidelines to different departments while developing the citizen charters. The elements of a good citizen charter can be understood if it focuses its focus on customer requirements, if it mentions the service standards, if it is effective, it provides for the effective remedies, if there is a training module, and if it is delegatory in nature, and most importantly, it must develop a feedback mechanism so that the feedback from the different departments, the different customers can be taken at any time so that the service charter can be improved. So the service citizen charter must be reliable, it must be responsiveness, it should have the element of responsiveness, or that means it should provide for timely the performance of services. Credibility, that means having customer interest at heart, it should aim at winning the interest of the or fulfilling the interest of the consumers, and it should have empathy or attention to customers' need, and it should have a courtesy and care, that means physical evidence of a willingness to serve. So these being the requirements of being a good ingredient of a citizen charter, the citizen charter must have vision and mission, and it must be located and identified in the service in a particular department, and the citizen charter must identify the levels of services, it must identify the client groups, it must specify the time limit for the delivery of services at each level, and it must be clear on service standards, it must maintain transparency. And many departments have gone for the provision for RTI also in recent times, and this also that means if the service the charters are not available, then one can resort to the RTI, and then the needful can be done. So the question is, so far as the limitations and so far as the experiences of having citizen charter in the country is concerned, there are certain studies. One is that the Administrative Reforms Commission, which published a report on so far as the working of citizen charter is concerned, it gave a guidance that provide for a grievance redressal mechanism for non-compliance of citizen charter and for matters connected therewith, so far as the citizen charter is concerned. Lay down an obligation on every public authority and to punish the citizens to publish the citizen charter, stating therein the time within which specified goods and services has to be provided. And it also provided for the preparation, implementation, and updatation of citizen charter as a key performance requirement, which will be evaluated annually by each department. So these are the suggestions given by the Administrative Reforms Commission. And now the question is what are the limitations, shortcomings that are being encountered by the citizens so far as citizen charter is concerned. It is understood, it is criticized that citizen charters in India are devoid of participatory mechanisms. There is no that in majority cases, majority of the customers or citizens, they have expressed the view that so far as the preparation of citizen charter is concerned, it is not having a consultative process through which the views and opinions can be taken from the citizens, and it is poorly designed, and the content is also not satisfactory. Lack of meaningful and meaningful citizen chatter, absence of critical information, and so that the end users find it is quite difficult so far as the citizen charter and its benefits are concerned. Lack of public awareness, and many majority of the citizens do not have the idea about citizen charter, because something like a citizen charter is existing and that is readily available for giving information to the different citizens visiting different government departments is not in the knowledge of the citizens themselves. And lack of that, so it is citizen charters are rarely updated. Once the citizen charters are made, that are not updated from time to time, sometimes 10 years or 20 years back, citizen charters are available, which makes difficult for the consumers citizens to understand, to really benefit from the citizen charter. And end users, civil society organizations, NGOs are not consulted so far as the development and updation and evaluation of citizen charters are concerned. Measurable standards of delivery are not defined. In other words, the citizen charters mostly, as it is studied, they do not contain the standards which can be measured, and one can come to a conclusion whether a particular department is following due standards or not, because the standards that is not properly measurable. That means, in other words, the citizen charters are not containing the proper standards of service, which is also understood as a stumbling block for the development, for the fruitful implementation of citizen charter. And tendency to have a uniform civil citizen charter is also there. Means most of the government departments, they have developed citizen charter, mostly they are same, but the services are different, departments are different, so the different departments must develop their citizen charter considering their own situation, own services, and that specific services that are being provided by the concerned department. So most important drawback of the citizen charter is that it is lacking a legal backing. That means, there is an absence of legal backing. The citizen charter is not legally enforceable and therefore non-justifiable. So one cannot move the court because of the violation of a citizen charter, because it is not justifiable. It is not backed by law. It is devoid of participatory mechanisms, as we have discussed just now. Awareness campaigns are not conducted in order to educate people and to train the staff to have a meaningful preparation and implementation of a citizen charter. And so far as the another important concern, so far as the citizen charter is concerned, is social exclusion. Means some educated and well aware person can take the advantage of citizen charter, whereas masses, those who are visiting for the services to different government departments, are not having this kind of opportunity, because either they are not aware, or maybe they are not educated. So there is a social exclusion. The issue of social exclusion is discussed by different literatures that is available so far as the implementation of a citizen charter is concerned. And keeping in mind this kind of limitations, the government of India developed a scheme called Sevatvam. Sevatvam means Uttam Seva, and obtaining Sevatvam symbol of excellence requires if a government department can obtain the Sevatvam or the certificate declaring that the particular government department is doing well, it must have a successful implementation of citizen charter, number one. Number two, service delivery preparedness and achievement of results, and it must demonstrate the sound public grievance redressal mechanism. If these three things are there or followed by a particular department, that department can be given a certificate of a Sevatvam. So the question is, what should be the approaches by citizens, by the different government departments to develop or to, so far as the implementation of citizen charter is concerned. So partnership between people and government. It is to be understood that the citizen charter is just not a document of information. Rather, it is a partnership between the people and government through which the healthy democracy can be built. Citizen charter is not a concept but a program of action. It is not to be understood that it is a concept to be read by the students in the textbook. Rather, it is a program of action because the service delivery which is taking place at every department is a action oriented program. It is a process, and it is a part of a democratic reform. The question is how to make our democracy strong, how to bring citizens at the center stage, how to make administration people centered. These are the questions, and the answer is one of the answers of such questions is the citizen charter. So the citizen charter as a concept which is conceived in order to make in order to make it as a part of democratic reform. People orientation and customer focus. Another important approach which must be understood or which must be developed by the different stakeholders of customer, the citizen charter is to have a orientation and a focus on the customers. The citizen charter is a proactive approach to good governance. If the notion of good governance has to be implemented and implemented in practice, then there must be certain steps, and the people's concept, people's commitment, people's understanding, people's empowerment is one, and citizen charter can fulfill to that direction. So far we have discussed some of the limitations. Some studies still exist. They find certain other limitations. A ritualistic and received document. This citizen charter should not be considered to be a ritualistic and a received document. That means it should not be relegated or considered to be just a document which is available in department in just a ritualistic, in a formal manner. Rather, it must be understood the value. The people must understand the value of this document, so that they can better way, they can participate the service delivery system in a better way. It must not be invisible and poorly communicated. The citizen charters that are available in the different departments must be visible. That means it must be clearly written and it must be properly communicative. If the concepts or ideas or language is such that it is the common citizens are not able to understand what it means, then it is not properly communicating. So the citizen charter must communicate properly so that the common citizens can take advantage of this. So one time exercise frozen time. That means the citizen charter should not be prepared once and it should not be kept for years together. It is a like changing. There must be some provisions to make it to change of time, and it is the citizens. The staff and the officials, those who are in the charge of implementing the citizen charter, so they must have accountability, and they should have a proper mechanism so that the address, if the lackings are there, it can be properly addressed. And one famous study was conducted by Public Affairs Center, Bangalore. In many Indian states like Andhra Pradesh, most of the southern states, and most of the northern states and Rajasthan, Gujarat, almost all states were covered by the Public Affairs Center. And in that study, which was done by Public Affairs Centers, they have studied almost more than 700 citizen charters which are available in different websites of different government departments. And that study revealed certain limitations of the public, so far as the citizen charter is concerned. It was found that 15% of the citizens, those who availed services in different government department, they were just having, they have seen what is citizen charter. And majority of the citizen charters, majority of the customers or the respondents, those who are studied by this study, they express their they express that they have not understood, they have not seen, they do not know what is citizen charter. So this is how the status of the citizen charter, so far as the Indian states are concerned, but especially the states like Kerala, Andhra Pradesh, Tamil Nadu, and some other states, including Maharashtra, they were doing good because most of the studies found that most of the citizens have some awareness and the government departments are doing well in these states. However, the states like Uttar Pradesh, Madhya Pradesh, Odisha, West Bengal, their performance was not up to the mark. So now the question is, this movement of citizen charter has remained just a concept, it is not actually helping the citizens to understand the value, and they are not able to take a benefit out of that, because these studies, they found that majority of the citizens are not aware, and majority of the staffs are also not having the right type of attitude to implement and to make it a successful. So however, there are certain variations, there are certain examples, case studies which shows that citizen charter are quite successful. Particularly the citizen charters in certain cities are quite successful so far as the studies are concerned. And one such study was reported from Hyderabad, like Regional Transport Office, for example. The Regional Transport Office developed a citizen charter which was displayed in its office, which discusses, which mentions all the informations that are related to the transport services concerned. So starting from learner's license and the cost of that, fresh driving license, what is the cost to be paid, registration of new vehicles, and different types of vehicles, what is the cost for each category of vehicles, and the issues, renewal of a fitness certificate, and light motor vehicles, medium motor vehicles, heavy motor vehicles. So issue of duplicate registration certificate. So all, and including the invalid carriages, motorcycles, and so endorsement or termination, light motor vehicle, and what is the cost. So all these informations which is displayed is considered to be one of the good example of a citizen charter, and because the citizens are having this benefit, those who are visiting this office, they are actually readily getting all the services, and the time also mentioned. If they apply today, what is the time limit, whether it is 1 day, some hours, or how many days, it is quite mentioned, it's clearly mentioned. So by the study of an NGO, one NGO studied, and they reported that this can be considered to be one of the good examples of a good citizen charter which is implemented in a very successful way in the city of Hyderabad. Similarly, another citizen charter example, which successful citizen charter case study was made in Jan Seva Kendra of Ahmedabad. And in that Kendra, it was found that almost every services that are available by different departments are readily available, and the citizen charters on each services clearly mention the detailed information which are required for each citizen who are visiting this Jan Seva Kendra. And this makes this it easy for the citizens to get the required services, and that is a success story how the Jan Seva Kendra of Ahmedabad made this citizen charter a successful document, and it involves the commitment of the staff as well as the clarity and of the document which mentions the details in a very clear language. So then another very good example of a citizen charter being displayed in Chennai Metropolitan Water Supply and Sewerage Board, which is also considered to be one of the case study where the details and procedures for grievance redress mechanism as well as other details have been mentioned. And that is why the question is, though we have so many challenges, we have to understand that citizen charters cannot be an end in itself, rather a means to an end, a tool to ensure that the citizen is always at the heart of any service delivery mechanism. So the overnight changes may not be expected in the country, though we have introduced citizen charter already long back, but there is no proper progress, expected progress. And gradual, untiring, and persistent efforts are required on part of both the citizens as well as the government service providers. And there is a need to have some attitudinal changes so that the successful implementation of citizen charter can be made. And gradual reforms by involving the staff, those who are opposing the introduction of citizen charter. That means it is seen that many government officials do not support the changes or the introduction of citizen charter, and that is why instead of having a complete reform, rather than some modifications in a gradual manner can be made, so so that the citizen charter can be successful. And citizen charter should have a inbuilt mechanism on monitoring, evaluation, and information. It should not be just a document where the details of the services to be availed by the citizens to be mentioned. Rather, it should contain in itself what is the mechanism, how to monitor, and how to evaluate and how to reformulate the citizen charter. This aspect also should be given emphasis. And one thing has to be remembered, that one size does not fit to all. That means, see, one model, one structure, one module of a citizen charter should not be adopted by different departments with a little bit modification, because the services are quite different, and on the basis of that, they should modify, they should streamline their citizen charters. Wide consultation processes must be undertaken in order to get the feedback, opinion of different stakeholders. Firm commitment to be made so that the citizen charter can be successful, and it can add or contribute for the healthy democratic system in the country. And periodic evaluation of CC should be made, and officers holding account that in charge of implementing should hold accountable for their omission and commissions, so that there should be some answerability so that it can be more effective. So with this, I would like to say that this citizen charter is quite a important document, instrument, which brings accountability on the part of the citizens, on the part of the service providers, but it is also a very good document for the citizens for their effective service delivery, and it contributes for the success of democracy. So if successfully implemented, the citizen charter can enable improved service delivery. It can bring greater responsiveness of the officials towards the public, and finally it can bring greater public satisfaction with the services they receive from different government departments. With this, I hope this would be enlightening, and I thank once again the organizers for giving me an opportunity to speak on this topic. Thank you.
Thank you, sir. Thank you for your valuable lecture on the topic of citizen charters and the Indian states. You discussed about the various aspects of the citizen charters and Indian states, and how can we implement the citizen charters. So thank you very much, sir, for your lecture, and your talk will enrich the knowledge of the all participants who are watching this program through YouTube, and the other students and the faculties, those who are watching this program. So thank you very much, sir, for our response, and I would like to request you for next time when we'll conduct that type of program, I think you will respond us. Thank you, sir. Thank you.
Thank you for this kind of kind talks. Thank you.
Thank you, sir. Now, I would like to go the next session, technical sessions, and the session for paper presentation. And I like to invite Professor Tuhin Kanti Das to chair this session. Sir, the Associate Professor, Department of Political Science, Belda College, Paschim Mednipur. Sir has done his graduation from Vidyasagar University and MA and MPhil from Bardhaman University. Sir has 20 years teaching experience, and he's published many articles in many reputed journals, and sir also write many chapters in different books, and sir also wrote many books on various topics. So sir also maintained many responsibilities, administrative responsibilities, and sir also take many responsibilities by given by the universities and the government. So I request Professor Tuhin Kanti Das to chair these sessions for few minutes. So over to you. Sir, please unmute yourself.
Okay.
Yes. Okay.
I again thankful to the authority for giving me the opportunity to chair the session as a whole. So time is very short due to paucity of time. We would like to start our technical. Is this as soon as possible? Now may I request Bornali Maiti, Department of Sociology, Ramnagar College, to present the paper. One thing before, the time is limited for us. That is only 5 minutes as per the direction of the organizing committee. So I Bornali request you just to mention your title of the topic as a whole, and the main theme that you are going to actually in the at the full paper you will elaborately discuss everything, but just to mention the focal point of your paper. Okay, thank you. May I request Mr. Dr. Bornali Maiti to present her paper. Bornali, please start.
Okay, thank you, sir. Respected chairperson and all the dignitaries and my dear students, have a good day. Now I want to present my topic entitled Child Abuse and Neglect, Focusing the Child Rights. Just in short, India is home to the largest child population in the world, with almost 41% of total population under 18 years of age. Child abuse and neglect is a violation of the basic human rights of a child. It is defined as a inattention or omission by caregiver to provide for the child health, education, emotional development, nutrition, shelter, and safe living conditions in the context of resources reasonably available to the family or caretaker, and causes harm to the child health or physical, mental, spiritual, moral, or social development. Children who experience abuse and neglect are more likely to have developmental delays and impaired language or cognitive skills, be identified as problem children, be arrested for delinquency, adult criminality, and violent criminal behavior, experience depression, anxiety, or other mental health problems as adults, engage in health risk behavior as adults, and have poorer health outcomes as adults. Now I have to skip some basic rights and provisions, especially for welfare of the children, and also some implementing policies due to time short, as sir already directed such areas have to. Now I want to focus main area, that is incidence and magnitude of child abuse and neglect in India. According to a survey conducted by Government of India, Ministry of Women and Child Development 2007, it was observed that prevalence of all forms of child abuse is extremely high, particularly physical abuse 66% and emotional abuse 50%. The report was based on a survey conducted in 13 states. It reported that in the age group of 13 to 18-year-olds, 23.2% of children experience physical abuses and who are not attending the schools. 26.5% of children experience some of other basic form of emotional abuse in the family settings, and 30.5% of school-going children experience corporal punishment at school. According to a recently held national survey by the Ministry of Women and Child Development carried out by NGO Proyas in association with UNICEF and Save the Children 2017, 50% of children in India are subjected to one or other form of physical abuse. A considerable rise in the incidence of abuse and crimes against children in India has also been reported in the last couple of years in Handbook of Ending Violence Against Children in association with Child Fund in 2018. According to the report, during 2016, a total of 10,06,958 cases of crimes against children were reported in the country as compared to 89,423 cases during 2014, an increase of about 20% according to NCPCR 2018. As per census 2011, 10.1 million, that is 3.9% of total child population are working either as main worker or as marginal worker. In addition, more than 42.7 million children in India are out of school. Child labor in India are employed with a majority of 70% in agriculture. As reported by Save the Children, children between the ages of 14 to 17 years engage in hazardous work, and account of 62.8% of India's child labor workforce, in which more boys than girls. That is 38.7 million versus 88.8 million, are forced into doing more hazardous work. Child labor used to be most ubiquitous in rural India, in which 80% of working children found work. As reported by UNICEF, there has been a 54% increase in child labor in urbanized areas of children between the ages of 5 to 14. According to 2005 Government of India NSSO, that is National Sample Survey Organization, child labor incidence rates in India is highest among Muslim Indians, about 40% higher than Hindu Indians. India has the highest number of children stunted because of malnutrition, that is 48.2 million, equivalent to Cambodia's population. According to Save the Children's Stolen Childhood Report, 31 million of children are part of India's workforce, the highest in the world. Child trafficking is an issue that is extremely prevalent in India and is continuing to grow rapidly. The trafficking of young girls under the age of 18 has grown 14 times over the last decade and has grown about 65% in the year 2014, according to the National Crime Record Book. According to the CBI, Central Bureau of Investigation reports, from 2009, there are an estimated 1.2 million children involved in prostitution in India. During the second wave of COVID-19 lockdowns, everything from hunger to child labor to child marriage is growing. That is 424 million children aged 0 to 17 years continue to be vulnerable. The causes behind these issues, poverty and inequality of resources, are two underlying factors relating to child abuse and exploitation. In India, child rights, protection and exploitation, that is street children, child labor, trafficking, etc. are intimately linked to poor socio-economic conditions in a large population base. It is still a neglected area which is strongly connected with parameters like poverty, maternal age of mother, illiteracy, single parenthood, social and family support, bonding with the child, attention or supervision to the child, economical support, knowledge about child development, etc. Now, few recommendations. Actually, there is a wide gap between policy and implementing policies and its outcome, and millions of children fall through the gap. So, in my interest, certain recommendation actually I want to mention. Illiterate parents are ignorant of their rights. They must be made aware of child rights, must demand and fight to obtain them. Multidisciplinary child professionals should work together and monitor the government efforts in protection of child rights. They should be able to national child health indicators, address key issues and concerns in the region, involve children in research and facilitate their participation in projects and policy development. India urgently needs a countrywide campaign against child labor and early marriage to protect its children from the economic and social consequences of COVID-19 lockdowns and loss of caregivers. So there is an urgent need to assign responsibility and accountability to government elected representatives, policymakers, proximate community and education and empowerment of families. So at last, I must say, a child is an asset to the nation, so it's the duty of the every citizen to protect them. That's all. Thank you. Thank you so much for hearing with kind patience.
Dr. Maiti, thank you.
Yes, sir.
Actually, within a stipulated time, you have finished your lecture.
Yes.
Okay. And one point is that you have identified so many problems from a statistical figure that you have presented in the lecture. So I think in your full paper you will mention all the aspects and give you some directions in this regard so that the problem would be solved. Thank you, Maiti, for your nice presentation. Now may I request Dr. Sujit Ghosh, Assistant Professor, Department of Political Science, Bajkul College. Actually, his paper, The Right to Food in India, a constitutional perspective, that is, I think that it would be a very good paper for us. Please, Dr. Sujit Ghosh.
I am audible, sir. তুহিনদা আমাকে শোনা যাচ্ছে?
Yes. So, Mr. Ghosh, I just request you to finish your lecture with scheduled time. That is very important. Okay. Thank you.
ঠিক আছে। হ্যাঁ, তুহিনদা আমি চেষ্টা করছি 5 মিনিটের মধ্যে চেষ্টা করছি।
বলো। Okay.
Good afternoon, everyone. My presentation topic is Right to Food in India, a constitutional perspective. Food is a basic human requirement to survive. The right to food is regarded as the most important human right. Realizations of all other rights depends on the right to food. The right to food is an inclusive right, means that all people have the right to feed themselves and their families with dignity. According to the Committee on Economic, Social and Cultural Rights of UNO, the right to adequate food is realized when every man, woman and child, alone or in community with others, has physical and economic access at all times to adequate food or means for its procurement. The right to food finds a place in the constitutions of India, although there is no explicit provisions for the right to food in the constitutions of India, but the fulcrum of justifiability of the right to food comes from few articles of fundamental rights and directive principles of state policy in the constitutions of India. Article 21 of the Indian constitutions provides the fundamental right to protections of life and personal liberty. The directive principles implicitly incorporate the right to food, either in the form of non-justifiable right of the citizens or in the form of directives in the nature of ideals of the state. And these are right to adequate means of livelihood, Article 39A, right of both sexes to equal pay for equal work, Article 39D, right against economic exploitation, Article 39E and F, right to work, Article 41, right to public assistance in case of unemployment, old age, sickness, and other cases of undeserved want, Article 41. The states shall endeavor to raise the level of nutrition and standard of living and to improve public health, Article 47. In spite of that, the Supreme Court of India has repeated in several of its decisions that the right to food is an integral part of the right to life guaranteed under Article 21 of our Constitution. So the Indian Constitution, the Indian Supreme Court acknowledges the right to food as human rights. In recent years, Supreme Court has been giving orders on right to food and right to work. In respect of the petitions of the People's Union for Civil Liberties, a Rajasthan-based organization in May 2001, the Supreme Court observed that it was the primary responsibility of the central and state governments to ensure that the food grains overflowing in FCI godowns reached the starving people. In September 2001, the Supreme Court has directed to 16 Indian states which had not justified the people below the poverty line to do so within 2 weeks and to enable the government to distribute food them under PDS, public distribution system. So it is the responsibility of Indian state to implement the constitutional recognized right to food. However, the policymakers of Indian state have taken different policies and programs for realizing right to food, such as public distribution system for improving food security at the household level, Antoday Anna Yojana for improving food security to the poorest of the poor, with implement programs as like MDNRGs for improving socio-economic conditions of vulnerable sections, various nutrition programs such like ICDS, midday meal. The latest manifestations of Indian government action on the right to food is the enactment of National Food Security Act 2013. It is a legislative measure of the government of India to guarantee nourishment to nearly 70 million Indians. However, in spite of many programs, there are concerns regarding food and malnutrition. The COVID situations make the problem more acute. Some of the worst violations of the right to food can be seen in India today. The problem of malnutrition is acute and widespread. It is extremely serious among women and children. The proportions of pregnant women with anemia is highest as 88%. At the all India level, more than 50% of children are underweight. On the other hand, India has accumulated more than 50 million tons of rice and wheat in public warehouses, largest accumulations in the world history. This demands much work still needs to be done at the national and state level so that a great share of population will enjoy nutrition subsidy. Thank you, Twinda.
Just one thing I would like to request you. Am I audible, Sujit? Am I audible?
Yes,
Yes. Just one book you are requested to go through. That is an Uncertain Glory. Jad Rez and Amartya Sen. Regarding your paper, you please go through that very book. Okay. This is my only. This is my suggestion for you. Okay. Okay. Next. Now may I request Shaumallo Ghosh to present the paper. Mr. Ghosh, you are requested to finish your within a scheduled time. Okay. Now please start.
Thank you, sir. My paper is on dilution of secularism in India under elected despotism, a threat to diversity and inclusiveness. Since its emergence as an independent country in 1947, India has attempted to maintain its composite culture. Unity in diversity is the spirit which has made India unique in the Committee of Nations. Two-nation theory, which had been put forwarded by Communal Muslim League to justify its political agenda, has been negated by post-independence Congress leadership in India. Secularism as an indispensable principle has been accepted to give equal footings to minorities. But this did not mean that the dream from a Hindu Rashtra purely based on religion was absent. But those forces did not gain momentum in early decades of post-independent India. But a watershed in the Indian politics in 2014 general election, which has witnessed ascription to power by right-wing political parties, has provided new energy to those dormant forces to attain its objective. Violence, atrocities, and intolerance against minorities are rampant. Even states' apparatuses are being utilized for this purpose. These steps have not only made minorities vulnerable, but they are losing their trust over the state machinery. This paper is an attempt to explore how elected despotism in India, through its deeds in recent years, has diluted the spirit of secularism which has put not only country's unique character in question, but it is also causing damage to country's long cherished principles of inclusiveness and diversity. Now, coming to my point, I would like to highlight one thing, that India has acquired multiculturalism from a very back date. There are numerous religions and societies present in India, and due to such multiculturalism, it has acquired for itself a striking character in the world. As it is said, one language, one culture, religion are the very foundation for creating a state. Yet India emerges as one of its exception, where it remains a nation with multiple cultures, language, and religion. India has invariably been a believer of the principle of unity in diversity, and the very concept of such unity is based on democracy, social tolerance, and the secular aspect of the state. Now, we all know that the Indian secularism is based on a composite culture, and sometimes, and mainly, it is called a civic nationalism, under which various communities has been given their wider acceptance, so that we can maintain the cultural pluralism of the Indian nation. But with the there is an interesting book in To Kill a Democracy, India's Passage to Despotism by Devashish Roy Choudhury and John Keane, published by Oxford University Press 2021, which dealing with the steady decline of democracy under the Prime Minister Modi. The authors document the functioning of parliament to suggest how democracy has corroded in the world's largest democracy, a country of 138 crore people. They cite that in 2008, 8 bills were passed in 17 minutes. In 2018, Parliament took 30 minutes to pass funding demands from 99 ministries and government departments, along with 2 bills containing 218 amendments. On neither occasions, adequate deliberations has been taken, that which reflects the process of decomposition of the Indian democracy has accelerated under the Modi government. Now, coming to the concept of the with the emergence of a right-wing politics, particularly we called it a majoritarian politics, we can see that the Indian nationalism has taken a character of the hyper nationalism, and one kind of forceful means integration is being applied in order to subdue the minorities, and the rights of the minorities are totally is in jeopardy. It is not only the through the politics, but the rampant misuse of the malpractices by the state apparatuses also has forced the secularism in the backseat. Now, coming to the question, there is, due to the shortage of time, I'm not able to look into the full-fledged paper. But the problem is that through the various means, like the mob lynching, then the discriminatory practices of the Citizenship Amendment Act, then the problem of ghar wapsi, then the problem of selling of the beef in the open, and this kind of means negotiation, this kind of law, which actually threat the pluralistic nature of the India. Now, in my problem, I will say that. You see that the Sweden-based VDEM Institute has harsher in the latest report on the democracy and said that India had become an electoral autocracy, and the last man in India, described as flawed democracy, slipped 2 places to 53 position in the latest democracy index published by the Economic Intelligence Unit. Now, what are the challenges to the Indian secularism? First of all, we say that communalism
Dr.
is
Ghosh.
one. Yes, sir.
Just to make it short.
Yeah, okay, sir. Yeah, okay, sir. I just told me. And the main problem is that we have the casteism problem, we have the communalism, then we have the party politics, and the more important fact is that when we talked about the secular politics, we have seen during the phase of the Indian politics and during the evolution phase of the secularism, we can see that there are several parties, though which in earlier times has maintained its a secular character. Now they are using the religious sermons, the religious symbols in order to gain momentum in the politics, which is a real threat to the Indian character. Now, in my suggestion is that secularism is relevant to and appropriate for India. The argument that it has failed is not well supported. There is no proof of how the state would have benefited had the Indian Republic been a more religion-oriented one. I think the alternative to secularism in India, as in other spiritually diverse societies, would be disastrous. secularism provides a check on the tyranny of the majority that is a natural part of any democratic society. It must therefore be defended and protected at any cost. Thank you, sir.
Dr. Ghosh, regarding your paper, I just make 2 points. One is
Yes,
what would be the appropriate meaning of the English word secularism?
Sir,
you just consider whether it would be a Sarvadharma Samanvaya or anything. You just one thing. And the another regarding your paper, I would like to request you to go through. Perhaps you have doubt it. Just mention. One is Ashutosh Varshney.
Yes,
a wide range of study that perhaps you know, and another that is Paul Brass and others edited by Paul Brass and all the others. Riots and programs and riots, most probably the title. Okay.
Okay,
so just request you these 2 books as a whole, and what would be the meaning of the word secularism? Just you consider it. Okay. And instead of secularism, Gandhian model may be followed. This is my humble suggestion. What Gandhi, that is Sarvadharma Samanvaya, in your paper that you have mentioned. So these 3 things. Okay. Thank you, Dr. Ghosh, for your valuable presentation. Now, may I request Dr. Ria Bhayal from Assam? You are requested to present your deliberation, but just request you within 5 minutes, you please just mention the basic points. Okay. Thank you, Dr. Ria Bhayal. Okay. Yes.
Thank you, sir.
Okay. Please proceed.
At first, I would like to thanks Professor Shyamol Pal who gave me the opportunity. In the last conversation, all professors gave us effective knowledge about the rights, justice, and etc. Today, myself, Ria Bhayal, give a short presentation about citizen rights. First of all, I would like to discuss what is right. All of you know that by Martin Luther, moral principles have lost their distinctiveness. For modern man, absolute right and absolute wrong are matter for what the majority is doing. In 1935, M.N. Roy introduced the Making Constitution, and Nehru Report for the first time made the demand of fundamental rights in India. To Making Constitution phase of company rules from 1773 to 1858 and Crown rules of
Okay, continue. Any problem?
There may be any device problem, sir.
Oh, that is a technical problem.
Yes, sir. Now you may call the next participant. I just call her.
Okay. Ria, madam, are you audible?
May I audible?
Due to some technical problems.
Yes, sir.
Connection.
Yes, sir. It is okay. It is okay now. It is okay now, sir.
Okay. You please continue.
Okay, sir. At first, I would like to thanks for Professor Shyamol Pal who gave me the opportunity. In the last day, all professors give the effective knowledge about the rights, duties, justice, etc. Today, myself, Ria Bhayal, give a short presentation about citizen right. First of all, I would like to discuss what is right. By Martin Luther, moral principles have lost their distinctiveness. For modern man, absolute right and absolute wrong, the matter of what majority is doing. In 1935, M.N. Roy introduced to Making Constitution, and Nehru Report for the first time made the demand of fundamental rights in India. To Making Constitution phase Company Rule 1773 to 1858 and Crown Rule from 1858 to 1947. Both are highly important and effective. The fundamental rights established in Part 3 of the Constitution of India. In our Constitution, fundamental rights include Article 12 to 35. There are 7 rights, but 1978, the 44 Amendment Act, the rights to property was abolished. Now the 6 rights are right to equality, right to freedom, right against exploitation, right to freedom of religion, cultural and educational right, and right to constitution remedies. First of all, the right to equality, the equality before the law and equality protection of the law. But all of these are changed at the time of nature and emergency period on foreign policy, etc. We see some of example in 1950, Satish Chandra versus Indian government case, and Southern Railway versus Rangachari 1961, etc. Equality is that is caste, work, untouchability of French Act 1955, that's called now Protection of Civil Rights Act, abolition of title, that's all are including rights to equality. Right to freedom discussed in Article 19 to 22, that's our freedom of speech and expression, the right to assemble peacefully and without arms, the right to from association and union, right to move freely throughout the territory of India, right to resettle any part of territory of India, the right to practice any profession and carry any occupation, trade or business. In here, the important case Venkatraman versus Indian government 1958, a highly adequate provision against the double jeopardy, and Provision Determination Act procedures on 1950. Another important part is held on 2002, that age of 6 to 14, all children are freely and compulsory education. Right against exploitation. Article 23 to 24, this act include here discuss about the wage exploitation, and also provision and regulation of the Child Labor Act on 1986, Factories Act 1948, and Minar Act 1952, etc. Freedom of religion, Article 25 to 28 discuss about the secularism, that outcome the Ratilal versus Mumbai State 1954, abolition of jizya tax, no religion education are totally prohibited. Cultural and educational right in Mohini Jain versus Karnataka State case introduced the right of education in constituent of fundamental rights. This article are include in Article 29 to 30. Constitution remedies, Article 32 to 35 reads there are 5 types: habeas corpus, mandamus, prohibition, and querenter and cesarize. The last remedies are given important of fundamental rights. So Indian Justice Gajendra Gharkar says the cornerstone of the democratic edifice raised by our constitution. Dr. B.R. Ambedkar said it is the very soul of the constitution and the very heart of it. Lastly, the least not but not the least, the fundamental rights are defined as a basic human freedom which every Indian citizen has the right to enjoy for the proper and harmonious development of personality. We give our own point of view,
Madam,
many aspects, but yes, sir.
Madam, just make it short.
Okay, sir.
Madam.
Let's do 2 lines. Only 2 lines, sir.
Okay.
Only 2 lines. I think whatever we do, that's all are followed from Constitution, and it is absolutely controlled by our Constitution. Thank you. That's all.
Madam, one thing regarding your paper, actually, so far as I know, the title of the paper, Right of the Citizen. Okay. Most probably this is the title of the paper, Right of the Citizen. Isn't?
Sir.
Madam?
Sir, yes, sir.
Actually, just request you to contextualize it. The right of the citizens and the Indian state or the Indian judiciary, in such a way, you have to contextualize it. Okay, this is my observation regarding your paper. Thank you.
Yes, sir.
Okay.
Yes, sir. Yes,
okay.
sir. Yes, sir.
And next, Sri Swarup Rana.
Thank you, sir.
Okay. Next, may I request Swarup Rana, Assistant Professor, Department of Political Science, Garbeta College. And his paper is very interesting. The title is The Right of the Persons with Disabilities and the Indian Constitution, a brief analysis. Mr. Rana, you are requested to start your deliberation, but to be remembered, you please remember the fact that within a time you have to finish your deliberation. Okay?
Can
Dr.
you
Rana,
audible?
please. Yes.
Sir,
Okay,
you,
continue. Yes.
Before reading this article, I would like to thank the principal sir, Ramnagar College, and the BCC chair by Professor Purkanti Das, and also thanks all the faculties of the Department of Political Science, Ramnagar College,
So I will start my research topic, right of persons with disability and the Indian Constitution and brief analysis. So I let start my topic. Various social thinkers understood and interpret the concept of disability. Disability is a condition in which a person is limited to daily activities. It is a complex phenomenon that affects the characteristics of a person's body and the parts of the society in which that person resides. Each country consists of a section of people with disability, many of whom are regularly discriminated against because they feel unwanted or rejected. People with disability have the right to enjoy human rights to life, liberty, equality, fraternity, security, and dignity by being human. But in India, disabled people remain an invisible category due to social indifference, psychological barriers, a limited definition of disability, entitling law protection, and lack of adequate data. The word disability has been used more recently instead of handicap or disabled, means with a differently able persons. India has many disabled people facing complex problems with attached social stigma and harmful attitude and much less resource availability. However, the Indian legislature has established various laws and policies to ensure that disabled people in India have equal legal rights as their citizen concerning employment, education, financial help, health facility, etc. This research paper deals explicitly with the current status of disabled people with present constitutional rights and policy in India relating to the rights of disabled people. The disabled right debate is not so much about the enjoyment of specific right as it's about ensuring equal and effective enjoyment of all human rights without discrimination by people with disability. The primary responsibility for ensuring respect for the right of persons with disability reset with the government. Our government has taken various steps to provide equal opportunity to persons with disability by enacting several acts, implementing various policy schemes for the empower of the persons with disability. Our constitution guarantees equal rights to each individual of our country. India is the one of the most past signatory of to India United Nations Convention on the Rights of Persons with Disability, which means we have to adopt it is full spirit. I can say more about this topic. Disability is a complex category as it has been and still is understood and interpreted by different people in very different ways. In almost all society, individuals with physical or intellectual anomalies have been assumed to be by the very nature of their condition interfere as the term disability carrier with the connotation of a lack of deficiency whether mental physical or sensory. It has been defined primarily in terms of medical defect. However, it is acknowledged that word disabled is it not a homogeneous category. The different kind of body variation, physical impairments, sensory defects, mental and learning inadequacy. Then we will discuss that as many as 70 million disabled people spread across India continue to treat as second-class citizens. For the marginalized discrimination are norms rather than exception. Faced with barriers to the stereotype attitude, they are generally viewed as objects of charity and welfare as the world merely goes to about the employing their most basic human rights. In 1992, India became signatory to the proclaim of on full participation and equality of people with disability in the Asian and Pacific region. This was adopted at the Beijing at a conference convention by Economic and Social Commission for Asian and Pacific region. proclamation brought a obligation upon the country to enact a laws as from affirmation, and so persons with disability, equal opportunity, protection of rights and full participation act of 1995 go through parliament.
Sarup,
Yes, sir. Yes, sir.
Make it short.
Yes, sir.
Okay.
We will then make a brief analysis of the various rights ensured in India Constitution on the rights of differently able persons. The Constitution secures to the citizens, including the disabled, a right to justice, liberty of so expression, belief, faith, worship, equality, and status of opportunity, and for the promotion of fraternity. Article 15(1) enjoy on the government not a discrimination against any citizens of India, including disabled, on the ground of religion, race, caste, sex, place, or birth. Article 15 to state that no citizens, including the disabled, shall be subject on any disability, liability, restriction, or condition on any of the above grounds of the Article 17, Article 21. Article 21 says every person, including the disabled, has life and liberty granted under the Article 21 of the Constitution. Article 24, prohibition employment of the children, including the disabled, below the age of 14 years to work in any factory and mine or to be engaged in other hazardous employment. Article 25 guarantee to every citizen the right to freedom of religion. No disabled persons can be compelled to pay any tax for the promotion or maintenance of any particular religion or religious group. Article 32, every disabled person can move the Supreme Court of India enforce his fundamental rights, the right to move the Supreme Court. It is granted by Article 32. And so, Article 29 to Article 45, Article 47 can be also rights to disabled persons. The health laws or Indian many others law are next most popular enacted by Indian Parliament. Equal opportunity and protection of rights and full participation. Article Act 1995 had come into force on February 7, 1996. It is a significant step which ensures equal opportunity for the people who is disabled and their full participation in the nation building. Thank you, sir.
Okay, Sarup, that is
Yes,
paper is very interesting and the new area of research. So I shall not make any comment regarding your paper as it is an emerging area of research. So please go through all the papers and all the basic writings regarding your research work. Okay, thank you. And now may I request King Shuk Panda, that is the paper that emergency provisions of Indian Constitution and its misuse at the state level. King Shuk, please start.
Am I audible, sir?
Yes, please.
Am I audible, sir?
Yes.
Good afternoon, everyone. First of all, I extend my thanks to the sir in chair. Then I am extend my thanks to Professor Samuel Pal, faculty, Political Science Department, Ramnagar College, and extend my thanks to all the participants. Myself, King Shuk Panda. My presentation entitled as Emergency Provisions of Indian Constitution and its Misuse in State Level. In a political system, emergency denotes a situation in which the chief executive imposes restriction on the rights of freedom of people. In India, such restrictions generally known as emergency provisions. It is imposed under some situations such as war, external aggression, internal disturbance, or armed rebellion, or financial crisis in whole of India or part of it. In Indian Constitution, emergency provisions are provided in Part 18 under Article 352, 360. Article 352 deals with international emergency, Article 356 deals with state emergency, and Article 360 deals with financial emergency. Generally, emergency order declared by the President on the advice of the Council of Ministers. However, the real power of emergency is exercised by the Prime Minister. During emergency, authority of state government enjoys subordinate positions to the central authorities. In the presentation, I want to look into the controversies surrounding misuse of Article 356 related to state emergency and its impact on federal structure and fundamental rights. I have followed case study method for this presentation. Article 356 of Indian Constitution says that if the President, on receipt of a report from Governor of the state or otherwise, is satisfied that the government of state cannot be carried on in accordance with the provisions of the Constitution, President may proclaim emergency under Article 356. Though it is to be approved by Parliament, then it can remain in force for a period of 6 months that can be extended for a maximum period of 3 years. Article 356 of Indian Constitution has been severely criticized than any other provisions of Indian Constitution because of hampering democratic ethos of the Constitution. Since the commencement of the Constitution, the proclamation under Article 356 has been issued more than 100 times. It was found that emergency provisions under 356 has been misused more than 20 times for political vendetta since the independence of the country till 1994. In 21st century, the misuse of these provisions has decreased notably due to S.R. Bomai case in 1994 and 44th Constitutional Amendment Act. There are several cases of misuse of Article 356. If we look at very interesting cases, if you look, first of all, if you look at the Punjab in 1951, Article 356 first imposed in Punjab, and in Punjab, Nehru kept Punjab's assembly in suspension for 9 months and 28 days to help the state Congress government get its acts together. And the most important example of misuse of such cases of such article is included dismissal of the first elected government by the communist leader E.M.S. Namboodiripad in Kerala in 1957. In 1980s, Indira Gandhi government dismissed state government led by opposition parties in several states. On the other hand, there are also examples in misuse of emergency provisions by the non-Congress government. One by Janata Party government when Morarji Desai was Prime Minister of the country in 1977. Another was the dismissed of the Congress Party government of state by the Janata Dal-led government under the leadership of V.P. Singh. If I look at cases in state level, particularly after 1994, we found four important cases. First of all, in Bihar, 2005, there was hung legislature and Supreme Court President applied the rule of 356. But the Supreme Court, it was challenged in Supreme Court, and Supreme Court ruled that the imposition of President rule without giving the chance to form new government is unconstitutional and nullified act by President. In 2014, Andhra Pradesh, during the chaos for formation of Telangana, President rule was imposed, but without taking the approval of Parliament. And in Arunachal Pradesh, in January 2016, due to horse trading, Congress MLA joined hands with BJP and made minority government, and President rule was imposed. But the Supreme Court declared, it was challenged in Supreme Court, and Supreme Court declared that the imposition of President rule as ultra virus and reinstated the dismissal of dismissed Congress government as in power. And in 2016 in Uttarakhand, due to split in state unit of Congress party, President imposed Article 356. But High Court declared that the President rule imposed by the President was unconstitutional and restored previous government in the state. Now, if I come to the conclusion, I will say three things that in Ambedkar's word, Ambedkar said that it will be the use of Article 356 will be used as a last resort. So, if I come to the conclusion, first of all, a public opinion that abuse of Article 356 is slowly and eventually is withering the democracy. A public opinion needs to be formed to stop the abuse of 356, and media and judiciary and civil society in the meantime play some proactive role in evolving the public opinion on the need to exercise the restraint when it comes to Article 356. The spirit of cooperative federalism and respect for individual rights in an atmosphere of access to information can preserve the delicate because the different organs of the government and help adhere to constitutional mandates. And secondly, there is a demand for deletion of this article or making provisions in the constitution to restrict the misuse of the article. And thirdly, there is a say of president, but in most cases we found that president led by ruling government and in the center, and he just support the center's action activities. So there also president there also need a strong opinion of positions president should be imposed, should be established. Thank you, sir.
Okay, Kisir, for your fine presentation, just one point I would like to mention. In your lecture, you have mentioned the Kerala, the dismissal of the communist government. Do you know the issue? What was the issue? Do you know? If no problem. Just find out the issue as a whole. Why that very government was dismissed? Okay. Thank you, Kaushik.
Okay, sir. Thank you, sir.
Okay. Next, my esteemed colleague Joydev Naik from Silda CS College. Joydev, please.
Hello.
Yes. Start.
Very good afternoon, respected chairperson and my dear colleague. I am Joydev Naik. I am trying to deliver about role of regional political parties in Indian politics. The modern democratic state will be unable to provide a state without a party. India is in the world. The beginning of political parties in India can be traced to the formation of India National Congress in largely as an group of English educated middle classes who use the Congress. A political party is organized on the basis of certain principles or programs which are implemented when the party gets the power to control it. They also play an integrative role by resolving conflict the various arrest. They accommodate them to articulate a change becomes possible. Party development in India is a post-independent phenomenon. At independent, there are only two political parties, or the name, the Indian National Congress and the Communist Party in India. With independence, many new political parties scheme. The first election were held. Many as 50 joined the during the of independence. The country has been a large crop of parties such as no other country in the world has witnessed. No stable party system has yet developed, at least nationally. Regional parties are parties whose influence and political support base are confined to a region or a sub-region representing interest of particular regions or linguistic groups or ethnic and religious communities. The support base of a regional party is limited to its region and it only seeks to serve the interest of its region. At independence, there had been only two regional parties, the Akali Dal in Punjab and the National Conference of Jammu and Kashmir. But since the late 16th and 70s, regional parties have been emerging in increasing numbers. Of them away, but most regional parties send their members to Lok Sabha have been playing a crucial role as balancing factor between the ruling party and the opposition in parliament. After 1998 and 1999 Lok Sabha election, the BJP, with a large number of regional parties, formed coalition government. The regional parties are destined to play key role not only in state politics but also in national politics. My paper is trying to analyze the trend of regional parties in Indian politics. Thank you very much.
To add two or three case study. Hello, Joydev.
Yes.
Next, actually try to add any one or two case study in your paper. The role of regional political parties in Indian politics. It just add one Jharkhand creation of Jharkhand state with Jharkhand Mukti Morcha.
Akali Dal in Punjab. DMK, AIDMK.
Yes. Any just to add one case study in your paper. Okay. Thank you, Joydev.
And Aam Aadmi Party in Delhi.
Maybe as per your choice, you do it. Okay. This is my suggestion. Okay. And next, Samuel Das.
Okay.
Next.
Sir, I think he is not present, sir.
Okay.
I think
the next,
yes.
Payal Saha. Next.
Thank you, sir.
From Goldbanga University.
Hello, sir.
Scholar. Okay. Continue.
Okay, sir. Thank you, sir, for giving me the opportunity. Today I discuss on disability rights movement since post-independence of India. The phenomenon of disability has agitated the mindsets of the people since the dawn of civilization. Especially since the decade of 1970s, the growing social and political movements of disabled persons worldwide have tremendously influenced the study and analysis of disability and rehabilitation policy. Throughout centuries, the disabled have been oppressed, marginalized, and stigmatized in almost all societies. They constitute a section of the population which is most backward, least served, and grossly neglected, who have been socially, educationally, and economically disadvantaged. Nowhere is this victimization more glaring than in matters of education, employment, and physical access. This lack of access and participation of the disabled person in the political process is as much relevant in the political system as in any other aspects of life. It has thus become almost daunting and challenging for disabled people in India to actively participate in mainstream politics or feed their ideas into the system. Insofar as the case of India is concerned, the disability rights movement is still in its infancy stage having sprouted since 1971 when the then Prime Minister Mrs. Indira Gandhi had announced in the Parliament that jobs could be reserved for the disabled. But it remained only as an announcement. Then, in this way, one by one, Mr. Advani, then officer on a special duty in the Ministry of Welfare, then National Fund government, all made promises, but no good responses was received from them for the rights of disabled people. Meanwhile, group for the rights of disabled persons and the overwhelming support for them started swelling. By early 1990s, almost 300 NGOs were involved in working throughout the country to create a barrier-free environment for the disabled. Thus, pressure for the legislation went on mounting day by day. Finally, after much heat and dust raised over the issue, the Narasimha Rao government agreed and constituted various subcommittees to investigate the different aspects of the bill. By 1994, as nothing tangible emerged and with time running out, a group of people banded together to form the disability rights groups. Initially, there were too many odds and procedural wranglings, but eventually the bill was passed by the Parliament in December 1995 and it was made effective from February 1996. The basic objective of the bill is to enable the disabled to lead an independent life. This act was an example of the success of disability rights movement. In the year 2016, the act was again amended and the type of disability have been increased from 7 to 21. At last, it is clear that the disability rights movement has brought about remarkable change in public perception towards disability. The Government of India has also taken several measures for the physical and vocational rehabilitation of disabled persons, and millions of rupees have been invested over this item in successive 5-year plans. However, the services provided are woefully inadequate and there is great disparity between the demand and supply of the rehabilitative services to the disabled. Thank you, sir.
Okay. And the next, my esteemed colleague, Pavitra K. Bormon. Please, Pavitra da.
Thank you.
Yes.
Respected chairpersons and my friend Tuhin Kantidas and all dignitaries and dear participants. Am I audible?
Yes.
Thanks to all of you. I am grateful to Professor Shyamul Pal for giving me chance to participate in this webinar. I want to deliver my lecture. My topic is Relevance of Local Government in Indian Democracy, a study of Kaliaganj and Gangarampur municipality. Local government plays a key role in facilitating public participation. The Municipal Systems Act requires municipalities to involve, consult and cooperate with the community. The Act grants local communities the right to contribute to decision making, to submit recommendations and complaints to the Municipal Council, to be informed of Council meetings and decisions, be updated about Council affairs and attend open meetings, especially the drafting of municipal legislation or bylaws, the drafting and decisions around financial matters, including budget, a performance management processes require public participation. In order to participate in municipal processes, we should conduct the ward committee and adhere to general guidelines on how to conduct ourselves. Local government refers to the governance of a village, town, or any other area smaller than the state. It is administered by an authority consisting of representatives of the local people. The authority is widely recognized. All government revenue is spent on local services. Local government services are separate from central and state government services. Existence of local authority, whose authority are elected and controlled by local residents. Local government serves many purposes. This government works at local level. There is a deep connection between the two concepts of democratic decentralization and local self-government. Democratic decentralization emphasizes local initiatives, planning, and decision making. Local authorities should be given the right to exercise their powers and to exercise their independence. Otherwise, it would not be possible to preserve local autonomy in limited local areas. Democratic decentralization is a political ideology and local self-government is its institutional form. The basic premises of this system is the governing of a region by the local people. Each country has small territories like districts, subdivisions, villages, and governance is the rule of the people of the local people by the local people, of the local people by the local people. No self-conscious person agrees to give up his right to run his own affairs in exchange for something. The concept of local governance comes from the idea of democracy. The panchayat system and municipal institutions have been cited as institutional means of bringing democracy to the people. Here I have mentioned Kaliaganj and Gangarampur municipality as unit of local government. Kaliaganj is one of the oldest towns situated within the eastern part of Raiganj subdivision and southeastern corridor of Uttar Dinajpur district. Within the Kaliaganj city, Kaliaganj municipality came out as a teeny municipality only in the year 1987. Total geographic area of the municipality is 11.67 square kilometer, which is divided into 7 administrative wards. As per the census 2011, Kaliaganj had a total population of 53,530, of which 51% were males and 49% were females. Population was Kaliaganj was 85% of population over 6 years. There is one police station, namely Kaliaganj, situated within the boundary of municipality. Kaliaganj is conveniently connected with northern area of West Bengal and northeastern states and cities of India as the state highway. Kaliaganj municipality intends to be pollution-free, culturally enriched urban area, along with self-reliant, transparent, pro-poor and technologically equipped governance, providing improved basic infrastructural services along with safe and healthy livings, eradication of illiteracy, poverty alleviation through gainful employment will be motto of the municipality. There are 1 degree college, 3 B.Ed colleges and Polytechnic college, 27 primary schools in municipal areas. There is a state general hospital in the areas. Drainage system of this area is quite good. There are adequate arrangements for roads and street lights. Arrangements have been made to reach drinking water from house to house. Various welfare schemes of the government got the people like Pradhan Mantri Awas Yojana, Kanyasri, Rupasri, rationing facilities, old pension, etc. COVID vaccination, the rate of COVID vaccination is satisfactory in the municipality. That is, the people have direct or indirect connection with the different departments of municipal administration. So the people are getting or enjoying their due rights from the local administration. The economy of Gangarampur is driven by agricultural farming, small business, handloom and handloom-based handicrafts. Important handloom potential areas are located in Bolla Kali, Belbari 2 and various parts of Gangarampur municipalities area. Important handloom products include cotton, ordinary shari, cotton mala, mala shari, ladies churidar, gents Punjabi. According to the annual report published by Director of Textiles,
just make it short. Pavitra.
Yes. Okay.
Just make it short.
588. Where are the rest of Gangarampur area has 252 looms? So, is every citizen should be responsible regarding their own rights and duties within the state? The democracy will be fulfilled. Thank you. Thank you, today's chairperson and my friends, Queen Kanti Das, for short time.
Okay, Pavitra. In the full paper, you will mention all the details. So far as I know, I personally know you very well. So in your full paper, you will mention all the aspects of these two municipalities as a whole. So being a chairperson of the session, I would like to mention 2 or 3 points. First, I am grateful to the authority, that is Ramnagar College, especially reference to the principal and faculty member Samuel. They have given me the opportunity to be with you and to chair the session as a whole. In the first session, I was a speaker, and this is the next technical session, and being a chair, just 2 or 3 points. Total the number of papers that we have received 9, and different aspects of the Indian politics, the applied part of the Indian politics. The speakers, they have tried their level best to raise the issues in regard to governance, in regard to the party system, Indian political system as a whole. And I think within a short period of time, they will send the full paper to the appropriate authority. And I request Samuel to make necessary arrangement so that a volume may be published. That would be the outcome of the academic exercise as a whole. So last 3 days, from Samuel, very honest in his profession as a whole. Honestly, he has done so many things. And last 7 days, so far as I can remember, around the clock, I am with him. And I have tried my level best to give you some inputs in this regard. And I think Samuel will make some necessary arrangement so that a similar volume be published in near future. Thank you all. And I again thankful to the authority for giving me the opportunity to chair the session. Okay, Samuel, thank you.
Thank you, sir. Thank you very much to you, sir. You have organized this session very smoothly, and all the paper presenters present their papers and raise different issues by their papers. So thanks to all the paper presenters who have participated in this program. And I also thank the listeners who are watching this program by YouTube. And especially, I would like to thank Professor Queen Kanti Das. As he say now that sir is with me from 7 days, and he also guide me in different problem solved by him, and that's why I like to thank very much to say, sir. Now I invite Professor Rajesh Patra, the joint convener of this webinar, to give vote of thanks and to close this webinar. Professor Rajesh Patra.
Thank you, sir. A very good afternoon. A very good afternoon to all. Now we are entering the last session, the 3 days international webinar on constitutional obligations, values, rights, duties, and responsibility to the citizens, organized by Ramnagar College. It gives me an immense pleasure to deliver the vote of thanks for a wonderful international webinar. I would like to thank our whole organizing committee, Special thanks to Chief Patron Sri Suprakash Giri, GB President, Ramnagar College, and very thanks to our Chairman, Dr. Ananta Mohan Mishra, Principal, Ramnagar College. And special thanks to Dr. Naranarayan Das, Associate Professor, Ramnagar College. And I also thanks Secretary and Convener of this webinar, Professor Samuel Pal, Assistant Professor, Department of Ramnagar College, and other members of the organizing committee, Professor Prashanta Kumar and Professor Ranjit Kumar Mandal, Department of Political Science, Ramnagar College. And also I thank to our today's chief guest, Dr. Tuhin Kanti Das, Associate Professor, Department of Political Science, Belda College, and Chief Guest, Dr. Vikas Das, Associate Professor, Department of Political Science, Assam Central University, Difu Campus, Assam. And last but not the least, our paper presenter, listeners, students, and all the listeners, for thank you, big thank. Thank you.
Thank you, Professor Rajesh Patro. Now, this 3 days webinar is going to end, and I hope that this 3 days webinar will improve the knowledge of the participant and also help the students to know it's not only students but also the citizens, because the title of this webinar is not only related with the students but also related with the citizens of India. So all the citizens will get very informative message or discussions from this webinar, and this webinar will be live on YouTube forever. So I would request all the participants and all the listeners, viewers to watch or to listen this 3 days program by YouTube, and that will enrich their knowledge. So thank you all for the participate in this program. Thank you, sir. Now I'm going to finish this program. Sir, Tuhin Kanti sir. Sir, can you hear me?
Yes.
Sir, may I close?
Yes. You can.
Thank you.
Officially, you please declare. Okay, no problem.
Yes.
Okay.
Thank you, sir. Thank you, sir.
Okay, thank you, Rajesh. Samuel also. Okay.
Thank you, sir.